Hello guys, I'm Shiv and welcome to my channel. And this video is totally a replica of my previous video which I've already posted, that is on punishment under I.P.C. But that's in Hindi language, and as I promised I'll post in English too. So here I'm presenting you the next video in English on punishments. So talking about punishment under section 53 of Indian Penal Code, it only talks about the types of punishment we have, like we have death penalty, or we have life imprisonment, or we have imprisonment, or we have fine. But that's not enough for punishment. We have to know, from where this punishment, came in existence, and what are the theories of punishment, or what are the types. Then we'll come to the types. So coming towards the study of punishment first, study of punishment, or we can say study of penology. Okay, what is penology? First of all, what is penology? Penology is nothing but a study of punishment. We have criminology, we have victimology, we have penology. Criminology means study of crime, victimology means study of victim, and penology means study of punishments. And for the study of punishment, for the penology, we have to know what is crime. And for crime, we'll go into the, the definition given by the Salmon. According to Salmon, crime is nothing but an act deemed by law to be harmful for society, okay, as a whole. Although the immediate victim may be an individual. Because an act, done with an individual, any offense done with an individual, it affects the society as a whole. So that is the definition given by Salmon. And if we, for this definition, if we can give an example, we can say that murder. Murder inquires primarily a particular victim. But its blatant disregard of human life put it beyond a matter of life, beyond the matter of mere compensation between the murderer and the victim's family. So the basic object of penology. So the basic object of penology is nothing but to protect the society from the criminals by inflicting punishment over them, by imposing penalty over them. Now, from where we can impose that punishment? So we have criminal law for that. We have Indian Penal Code for that. And when we talk about punishments, punishment is not a single punishment. We have two, segments of punishment. We have two types of punishment. The first one is, hard punishment. Another is soft punishment. And in the case of Madhab Hayawadan Rao versus State of Maharashtra, a case of 1978, court clearly states that the court has to be cautious while giving, sentence. Because sometimes soft sentencing, is the gross injustice to the, victims, for many innocents who are the potential victims of that, of that criminals. So court has to be cautious while giving the judgment. And crime and punishment, as we are already talking, crime and punishment are the two faces of the same coin, because punishment must fit the crime. Court will, can give life imprisonment for causing hurt under section 323 of I.P.C. So the punishment, if there's a punishment, there must be a crime. In short, if there's a crime, there's a punishment. And for that crime, the punishment should be the apt one. For, if a person is committing a very simple offense, you are giving a very hard sentence. That should not be there. And, for criminal offenses, we have I.P.C. in India. Indian Penal Code 1860, we have I.P.C. in India. And I.P.C. only prescribes the maximum punishment, and in some cases it also prescribes the minimum punishment. And there's a reason, because we don't have any statutory sentencing guideline in India. In short, we don't have any statutory sentencing policy in India. We don't have any policy which states that, if this amount of murder is done, we'll give this punishment. If this amount of murder is done, we will provide this punishment. If this amount to this amount of murder, we'll give this punishment. We don't have any such policy in India yet. So, talking about the definition of term punishment, we have already studied all sections from 1 to 51. You guys have already gone through that sections, and you have nowhere seen that, there's a definition of punishment. Because there is no such punishment, definition of punishment is mentioned. So, according to the Concise Law Dictionary, punishment is nothing but a penalty for the transgression of law. So, that's a very simple definition. If anyone, we can say violate any law, penalty will be imposed, and that penalty will be the punishment. So infliction of punishment serves as the ointment. Okay, it serves as the ointment on the wounded feelings of the society, because whenever crime is committed, it is not only the victim who suffers. It is not only the victim who suffers on that with that offense, but the conscience of entire nation is shaken. The conscience of entire nation is shaken to its very foundation. So that's why any offense which is committed, it does not only affect the individual, but also affects the state, because I.P.C or criminal offenses are the acts in rem, not acts in personam. Now, in the view of all these, we can say that the four aims of penology, or the four aims of punishment, are deterrent, preventive, reformative, and retributive. And we'll discuss in the form of theories all these aims. We'll discuss in the form of theories. So when we talk about theories of punishment, because theories of punishment totally deals with the aim of punishment. And when we talk about theories, the first we have is a deterrent theory. We know what deterrent means. That deterrent, it does not only want to prevent the wrongdoer from committing the second time, but it wants to make an example for the others, so that before committing that crime, they should have that an example. Okay, if we do this act, this can be done with us. And in short, we can say that it's a warning to all like-mindeds. So deterrent theory includes punishment like whipping or death by stoning, and it was a basis of criminal jurisprudence of England in the medieval period, and it is still following in some countries like in Pakistan, Iraq, Iran, and Saudi Arabia. It is still following, but every theory has some merits and demerits, and the main criticism of this theory is that it proved ineffective in checking crimes, and also the excessive harshness. Sometimes excessive harshness tends to defeat its own purpose of that what we want to develop is that we want to set an example for the others. But by giving harshness, excessive harshness, harsh treatment to the criminals, it tends to arouse sympathy of public. So yes, it is the criticism for this theory. Now the second theory is the preventive theory. Now preventive theory, with the form word preventive, we can judge that it concentrates on prisoners, and it seeks to prevent them from offending again. Now how can they be offended? How can they be prevented from offending again? By death penalty or by exile. Now these two are there, but this theory doesn't differentiate between men or women. It doesn't differentiate between child or adult. It doesn't differentiate between the first offenders or the second time offender, or the who are offending again and again. So the main criticism of this theory is only this, that it has very undesirable effect on hardening first offenders and juvenile delinquents. So this is the main criticism of this theory. Now the third theory is retributive theory. Now retributive theory means to recompensate, or we can say that in revenge. So in primitive society, punishment was mainly retributive in nature, and person wrong was alleged to have revenge against the wrongdoer. And in the case of Shiv Ram versus Stae of U.P., a case of 1998, the court held that the principle of eye for an eye, limb for a limb, a nail for a nail, or tooth for a tooth was the basis of criminal administration. And advocates of this theory always pleads that, criminal deserves to suffer because criminals are already wrong in, nature. So criminal deserves to suffer. And in modern times, the idea of private revenge, has been removed, because there's a main criticism to this theory, that is, punishment in itself is evil in nature. And when we talk about revenge is nothing but a justice gone wild. So that's why this theory is also not a foolproof theory. Now coming to the fourth theory, that is reformative theory. When we talk about reformative theory, the main objective of this reformative theory, from the word itself, we can, judge that it means reformation of criminals. That means rehabilitation of criminals. When we talk about drug addicts, they sent to rehabs. So, okay. Similarly, when we talk about reformative theory, a criminal, sent to jails, they must be educated. They must taught some art or craft or industry, during the term of his imprisonment, so that he may be able to lead a very good life and become a very responsible citizen and a respectable citizen, after release from jail. So it is a very good theory, and it should be followed, but still there is a criticism to this theory. And criticism is that, if criminals are sent to prisons to be transformed into a good citizen, so a person will no longer be in a prison. That person will be in a dwelling home. That is the main criticism to this theory. But since we have all theories, and every theory is not foolproof, and every theory has their merits and demerits, there is a theory that is known as multiple approach theory, which is followed in every single country right now. Because, a perfect system of criminal administration or criminal justice cannot be based merely on a single theory of justice. And it would have, combination of all. So since every theory has their own merits or demerits, and effort should be made. Since every theory has, some viable points, some good points, and some bad points. So some efforts should be made, to extract all the good points, of each theory and integrate it so that a best of all could be achieved. And for example, we can say that reformative aspect must be given, its proper place, or the offender is not only a criminal. See, this point, the offender is not only a criminal, but a patient to be cured. This is the main tagline, we can say, that of this whole theories. Because if we get clear of this picture, that the criminal is not only a person who is who has to be punished, but it is a patient who has to be cured, then we'll get to know what type of criminal administration or criminal justice we need in our country. So punishment should be proportionate to the nature and the gravity of that offense, and first offender should be dealt leniently, and special treatment should be given to the delinquents, juvenile delinquents, and special courts should be made for childs or for women, etc. So this multiple approach theory is the best theory, which is still followed in many countries, many countries. And in a case of Narottam Singh for India, in a case of Narottam Singh versus State of Punjab, a case of 1978, court said that reformative approach, to the punishment should be the object of criminal administration. So it should be the basis of criminal law. Because, if we don't have reformative system, then the basic purpose of, punishment goes in vain. So yes, reformative approach should be followed in every single country. And in India, yes, we have reformative approach. We have, different laws for juveniles. We have different laws for juvenile. We have different laws for the first time offenders. And we have juvenile homes for the juveniles. So yes, the reformative approach is still followed in India. Now coming to the last segment of our video, that is the classes of sentencing, the types of punishments. Section 53 of Indian Penal Code states the types of punishment we have. We have, death penalty, we have imprisonment for life, we have imprisonment, we have forfeiture, we have fine. So starting with the first, that is the death penalty. And for death penalty, there's a famous case of Bachchan Singh versus State of Punjab, a case of 1980, in which court clearly states that the death penalty in the cases of murder will be awarded in the rarest of rarest cases. And yes, it is the first case, in which death penalty is given in the case of murder. So death penalty can be awarded for the other offences under I.P.C, like for example, waging war against government under section 121, or abetting mutiny actually committed under section 132, or giving or fabricating false evidence under section 194, or murder under section 302, or attempt to murder under section 307 part 2, or kidnapping for ransom under section 364A, or dacoity with murder under section 396, etc, etc. We have many more offences in which death penalty can be given. So the second one is imprisonment for life. And imprisonment for life, it is for the whole life you have to stay in jail. And section 57 clearly substitutes imprisonment for life for 20 years. And offences under I.P.C clearly states that which offences has to be for imprisonment for life, and in which cases we have rigorous imprisonment or simple imprisonment. We have all offences mentioned in I.P.C mentioning the type of punishment which can be provided. So the imprisonment for life is the second one, and the third one is imprisonment. And when we talk about imprisonment, the imprisonment is not a simple imprisonment we have in India, but we have both rigorous and simple imprisonment in India. And for that distinguishing between rigorous and simple imprisonment, we have a case of Phool Kumari versus Office of Superintendent, Central Jail, Tihar, New Delhi. It's a case of 2012, and it clearly distinguished between rigorous and simple imprisonment. And according to this case, the court held that the rigorous imprisonment is nothing, it is required by a law to be completed with hard labor, and in simple imprisonment there is no hard labor. That's the only difference between rigorous and simple imprisonment. That hard labor is there in rigorous, there is no hard labor in simple imprisonment. And in hard labor you have some work to do, like stoning, crushing stones, or anything. It can be anything with hard labor. It can be mining or anything. And for rigorous imprisonment, we have offences like rape under section 376, or we have giving or fabricating false evidence section 194, or house trespass, etc. we have in rigorous imprisonment. And for simple imprisonment, we have wrongful restraint under section 341, or misconduct in public place by drunken person under section 510, or defamation 500, 501, 502, etc. we have for simple imprisonment. And the maximum punishment which is provided in India is 14 years, and the minimum is nothing but a 24 hours. And 24 hours is only mentioned in a single section, single offense, that is 510 section, which talks about misconduct in public place by a drunken person. So this is the third is imprisonment. The fourth is forfeiture, and the punishment for absolute forfeiture is now abolished in India, and section 61 and 62 deals with forfeiture, but they are now repealed in India. It is clearly mentioned in the Indian Penal Code. You can see there. And the fifth is fine. Now for the every offense, when we see in Indian I.P.C BAIR Act, if we see there's written imprisonment for 7 years or fine of rupees 10,000 or both. Usually there is fine with imprisonment, but in some offences there is only fine, and fine is the only option in the cases under section 137 or 154, 155 or 156 or 171 GHI or section 278, 283, 290, 294A. There is the only option of fine. So guys, this is the whole the part of punishment. We have done the basis of punishment, we have done the theories of punishment, and we have done the types of punishment. And guys, still I'm repeating the same line in every video. I used to repeat the same line. Like if I missed anything, or if I by mistake I was said something wrong, or some wrong section which I have delivered, I'm always open for suggestion, and you can mention in the comment section. And I hope you like this video, and I'll post the next video soon on the next topic. Thank you so much, guys.